Hey, all right. I'm just going to go over these review and enrichment questions real quick here. If you were curious and maybe wanted to use these to study a little bit for your test. Anyway, review and enrichment at the end of your notes, going over 2-4. All right. So, question one. Often terms are agreed upon before the case gets to trial. These terms are called, and that one is settlement agreement A. Number two, what are the typical contingency fee percentages for attorneys? 40% is very common. It can go up and down from there. But typically there's also a scale depending on how much work they have to do. If it's something that's settled before trial, uh, it's probably going to be cheaper, probably between 25 and 33%. If it's something that is getting appealed and even more work goes into that, it can get over 40%. But most of the time, it's going to be between a third, 33.3, and 40%. All right, number three, how many arbitrators usually handle a dispute? Well, it's one or three. If it's a more complex, bigger lawsuit, not lawsuit, but bigger issue, then it will be three. Um, but sometimes for smaller cases, then it will be one arbitrator. Number four, suppose you receive a concussion from a hard tackle in a football game. Would the fact that you signed an assumption of risk waiver prevent you from seeking damages in civil court? Yeah, absolutely. That's the purpose of the assumption of risk waiver. And the thing that I'm getting at here kind of is um, that's something that is going to happen during a game. That's something that you would expect. Now, if um, a player takes his helmet off and tries to hit you with his helmet, like Mason Rudolph, I forget the Bengals name right now, but that is not something that's part of the game. So even though he, I'm sure, has signed an assumption of risk, then he can still sue for that. Um, Number five, what is the difference between subpoena and a summons? Well, both are orders to appear in court, but a subpoena is because you have some kind of evidence or testimony they want to hear from you. But a summons is that you are getting a complaint against you. Number six, what are some items that typically cannot be seized to pay debts? Well, this is kind of a tricky question because it really depends on what the circumstances are. You know, more or less, you could have almost everything taken away from you under the right circumstances if you put it up for collateral. But let's say you declare bankruptcy. Um, so typically, they're going to need you to liquidate um, the assets that you can, but they're not going to take uh, the car that you use for work or your home in most cases. But that, you can still lose those things. Um, so don't want to get too deep into the weeds on that one. Number seven, what is a class action lawsuit? Well, this is when you have a large group of people coming together for one lawsuit, and usually has one person at the head of the forefront of it, but um, looking for looking for a whole huge group to collect. So, for example, if um, a group of people wanted to sue a um, uh, cigarette manufacturer, they could all sue. And if they, as a group, were awarded $10 million, then they would divide it up amongst the group. All right, and number 8, Liebeck versus McDonald's. This is a really an interesting case, and I wish we were in class to debate it a little bit. But you have this woman that buys a cup of coffee at McDonald's, and she ends up spilling it on herself, and and then she sues because she gets burned. And I'm sure that you kind of came to the same conclusion with the information that I provided, kind of leading you there, that the coffee was served too hot, and the amount of burns that she received, and they had complaints, and they didn't have any warnings on the cups. Um, and she was awarded a lot. She was awarded 3 point some million dollars. All right. Again, let me know if you have any questions, and that's your review and enrichment. Thanks.